Stewart, who gave us, I think, a wonderful perspective from someone who's had to deal with these cases before him in terms of environmental sentencing, to a practitioner's perspective and what a practitioner we have. I think everyone in this room knows of Diane Sachs. For several decades, she's been one of the leading litigators in environmental law, as well as managing to find time to be one of the leading writers in environmental law in Canada. And we are very grateful that we have found her. And welcome, Diane, and I'll turn the floor over to you.
Well, thank you very much for that gracious introduction. I'm sorry I couldn't be there with you today. Sounds like a great conference. What I was asked to do is talk specifically about directors and officers, and now I realize I'm not sure how to advance this. There we are. Oh, well, the formatting's a bit mucked, but I hope you can read it anyway. So I wanted to talk about two areas where the courts deal with directors and officers, one on sentencing and the other on regulatory orders. My three main beefs about the way the courts deal with environmental issues have to do with fairness, with science, and with not taking the issues seriously enough. And of those, fairness is always my top issue. And one of the things that I'm hoping that I will encourage you to do is think about how difficult complying with environmental laws often is. Now, sometimes it's pretty straightforward, and that's why I've said here there's the crooks, there's the well-intentioned, and if you can read it, the well-intentioned but confused. And in terms of the crooks, people who deliberately commit environmental offenses, I've got absolutely no sympathy whatsoever, and I just don't think that the courts take it seriously enough. But there's also a very large number of environmental offenses that come before the courts dealing with people who didn't intend to commit the offense. And I don't always see enough understanding as to how difficult compliance is, how confusing the laws are, how badly written the permits usually are, and why problems happen. So I'm hoping to talk to you about that for a few minutes. And I also want to talk about regulatory orders. And we now have a very strong acceptance, certainly by the regulators and also by the courts, that it is all right to impose enormous retroactive environmental liabilities on the innocent. And I think it's outrageous, and I'm hoping to persuade you the same. We control the window layout. Okay, don't think that was for me. So Justice Stewart, of course, is the one who set out the environmental principles in the first place the sentencing principles for environmental cases, and his principles have really stood the test of time. We use them every single time we go to court. They're still the important foundation. It is much more commonly accepted now than it was when he wrote them, but they're absolutely still the principles. And basically, you've got um, these features that I'm sure you heard of from him. Sorry about the way this has come out. I hope you can read it. On our version, the tree is quite faint and doesn't interfere with the text. Can I ask the monitor, do people have a copy of the presentation in a format they can read? I can't hear anybody, so I hope you can. Anyway, these are the environmental sentencing principles. I'm sure that you're used to them. You'll notice, though, that what isn't on there anywhere is anything about how good was the science that the Crown relies on, because sometimes it's very good and very often it's not. And there's also nothing on these principles about the role that the government played in contributing to the occurrence of the offense, which is another factor that I would certainly like to see the courts pay more attention to. It gets picked up to a certain extent in terms of attempts to comply, but that's difficult given that the Supreme Court has told us that ignorance of the law is no excuse, even if you have attempted to find out what it is, unless you can get all the way to officially induced error, it doesn't count as due diligence, and so it will have to come into this area of attempts to comply. In terms of the crooks, the biggest area of what I think of as true criminal environmental behavior is in wildlife uh, trafficking, the illegal trade in wildlife. I was very surprised to learn is the fourth largest worldwide moneymaker for organized crime, something like $17 billion a year. It is just an enormous area. And we don't have charismatic megafauna like lions, but we certainly do have polar bears and a whole series of endangered species, threatened species, species that are endangered by wildlife crime, and I hope that that's something that people will take very seriously. Regina versus Sinclair is a case which is more common, and it's having to do with contaminated sites. And as you're probably aware, we have tens of thousands of contaminated sites in Canada, usually due to a history of weak or entirely absent regulation on the uses of various industrial chemicals, a history that is continuing today. In any event, this case deals with a PCB contaminated site near the Bay of Quinte in Ontario, and the site was contaminated over decades by giant companies making a lot of money who then closed down, sold the site. Anyway, this Mr. Sinclair foolishly bought this contaminated site and figured that he would make a lot of money developing it because, after all, it was waterfront property. But it was not only badly contaminated, it was wetland. And so he said, all right, nope, no problem. He's a can-do kind of guy. He got a bulldozer and he went out there and he started digging trenches through the contaminated wetland, not only destroying the wetland, but also, as it happened, releasing huge amounts of PCBs into the Bay of Quinte. And I understand from my ministry former colleagues that this is the source of basically PCB contamination throughout that entire watershed. um, Meredith, my associate, has put this helpful picture in. I don't think Mr. Sinclair actually looks like that, but the judge described him, perhaps having gone to this thesaurus, as obnoxious, despicable, arrogant, deplorable, insulting, demeaning, confrontational, totally incorrigible, and completely uncooperative, which had certainly been the ministry's experience of the man. This is not someone who committed his offense by accident or unintentionally or with any misunderstanding of what he was doing. He was told, he was told, he was ordered. He was simply not going to listen. He intended to make money by developing this property, and he didn't believe that anyone else had the right to stop him. So if you think about the worst offender and the worst offense, he didn't kill anybody directly, but certainly the worst offender, and the offense is very serious. PCB contamination, once it spreads into the environment, it doesn't break down. It's almost impossible to clean up, and it stays there, poisoning wildlife, fish, and adversely affecting people for a very, very, very long time. So what do we get? We got some fines that I think everybody knows won't be collected, and a 4-month jail sentence. I don't think that that is commensurate with the degree of the importance of the offense. And so it's an example to me of the court simply not taking this seriously enough. We do sometimes see very large fines being imposed on these small companies, almost always with no prospect of collection. So it doesn't do much in terms of either general or specific deterrence to impose a very large fine that won't be collected. And there isn't a very robust system to pursue these things anyway. So that's an example of my frustration on sentencing. It was upheld. The prison sentence was upheld. The corporate fines were reduced. And so, would jail make a difference for some of these people? Would anything have made a difference for Mr. Sinclair? I guess I can't say that. But I look at it in comparison to the amount of harm to the public interest, and it just doesn't look to me as if it's being taken seriously enough. Now then we have all kinds of people who are trying to comply but just finding it difficult. And the real challenge with environmental issues is that they make accidents illegal. It's the same sort of thing that you have for occupational health and safety. But there are more things that can go wrong in more different ways. So very often the offenders that end up in front of the court are people who've had an accident of one kind or another. Um, and with 2020 hindsight, it's always obvious that that accident could occur. Problem is, of course, that 2020 hindsight doesn't really help you figure out what it was like for the person at the time when they were trying to plan in advance. Um, Now, there are, for officers and directors in particular, this question about to what extent should they be responsible for accidents requires some pretty fine balancing. Most of the cases in which directors and officers have been convicted of things like spills deal with small, closely held companies where the directors and officers are the directing minds. And so when you get to a very small company where you really have only one or two people making decisions, well, it isn't hard to say that if the person was running the organization, one of the classic cases on this was a chap who ran an illegal cable television system in Sault Ste. Marie. And everybody knew it was, they were trying to get around the CRTC rules. He was running it. He knew they were trying to get around the CRTC rules. So there isn't any difficulty to say that he was directly committing the offense as well as the corporation. The question comes when it's not a corporate intention to commit the offense, it's something that occurs as an accident. And then we get to there's two ways in which directors and officers can be prosecuted and convicted for those kinds of events. Number one, directors and officers can, as in the Cablevision case, actually commit the offense as a principal or a party, comparable to Section 21 of the Criminal Code. But there are also, and for those folks, I don't think there's any difficulty in sentencing. The same principles apply to them as to any other offender. But we have these other kinds of provisions, such as Section 28.1 of the Canadian Environmental Protection Act, and somewhat similar provisions in environmental statutes in the various provinces, which says the directors and officers have to take reasonable care to ensure that the corporation complies with certain things, which includes government orders. The second bullet there is about ships and dumping from ships. I'll leave that one for the moment. But this question of what does it mean to take reasonable care to ensure that a corporation doesn't have an accident is very hard to parse when the accident hasn't happened. Because when you start any day, there are 1,000 things that could go wrong on that day. You don't know what they are. And it's only after the accident has happened as we look back with 2020 hindsight and say, well, yes, that one happened, and so of course everybody should have seen it happening. And I'm sorry, I can only see myself on the screen. I can't see anybody in the audience, so I don't know if you're awake or asleep or finding this helpful or not. Maybe somebody can type me something just to say, is the audience following along? Are we doing okay here? Is the pace working for you? It's very hard to give a talk without being able to see anybody. So hopefully somebody will type me something. Other than that, I'll keep trucking. So the directors and officers' question about taking reasonable care. It's very hard to prove that you, oh, thank you. It's very hard to prove that you have done everything possible to prevent all accidents, partly because it's always possible to do more. But there's a cost, and if you do more of one thing, then you have to do less of something else. There is, in the business world, a system of identifying and ranking risks, often called a HAZOP system, which seems to me the sort of thing that courts should want organizations to do. And I'm not saying companies, because it's not always companies, it can be municipalities, it can be governments, it can be charitable organizations. But for all of them, there's an infinite number of risks, and there is a limited amount of resources. And so, with every ministry developing its own statute and every ministry thinking that its own issues are the only ones that really matter, there is no overall framework for deciding how corporate resources or organizational resources should be allocated to preventing risks. And I sit on a risk management committee of a charity, and it's very difficult to know how much do we spend on preventing people from slipping, how much do we spend on making sure that there's no sexual assault, how much do we spend on making sure that all of the taxes get paid on time, how much do we spend on making sure that the soil cover over the contaminated area is enough. And so it seems to me that the courts should be encouraging organizations to have a rational, thought out plan in advance to identify hazards and to rank them and hopefully to deal with them more or less in order of priority, which is probably what you'd want to do yourself if you were in charge of these things. And I have never seen that accepted in the courts. We had one case in British Columbia where Imperial Oil, listen, I'm not a big fan of Imperial Oil by any means, but they did have exactly such a system to try to rank risks and to get to them in order, and they were dealing with the higher priority ones, and then a low priority one happened, and they got prosecuted and convicted, and so that doesn't help so much. Oh yes, Meredith tells me that the site's coming, which is great. Thank you. So there it is. All right, the site's right there, and that is something that I hope that the courts will consider is, given all the other potential risks that the management and the board of directors had to consider in advance, not just the environmental ones, although that's obviously my area, it needs to be an overall view. Is this something that they should have recognized or not? And the courts have been, I think, they have underestimated how difficult it is to know in advance which are the risks that have to be attended to first. Yeah, so we've had a case recently where an environmental manager who we know is absolutely committed to doing a good job and is an officer of her corporation, and she's the kind of person who stays up nights giving herself an ulcer, worried about trying to make sure she does everything right, and when things go wrong that are unexpected, she runs in and tries to do the absolute best that she can, but sometimes she makes a mistake. In one case we had recently, she was called sump pump broke down, and then the basement flooded, and the interlock to shut down the equipment where the water came from didn't go on for about 15 minutes, and by then the whole basement was full, and so they run around, spend the whole time thinking they had everything contained on their property, and they didn't find out until 3 hours later that in fact some of the liquid had actually flowed right through a retaining wall, which frankly looks perfectly solid from the outside, but turns out to have cracks on the inside, and had gone out the other side and had been flowing down the sidewalk through another property and towards a creek. And so by the time she got that reported to the ministry, it was 3.5 hours after the flood. So will she get charged with failing to report a discharge? She may. The statute says it has to be reported forthwith. This is an example of someone who absolutely does not need punishment to make her work harder. I know that she's already working as hard as she possibly can, but it's not a perfect system. So I thought I'd tell you that just in case you've never been in the situation of trying to figure out what do you do first. And she was putting almost all her emphasis in trying to control the spill and trying to get a vacuum truck and trying to absorb it and trying to deal with the problem in the flooded basement, and didn't think hard enough, fast enough about calling the ministry, not that they did anything useful when she called them. They do often do things that are useful, just not in this case. One of the issues where I think the courts have particularly failed to understand the difficulty of the regulated community is where the regulated community really cannot reasonably tell what the law is. And castingate blasting, a recent decision by the Supreme Court of Canada, is an example of this that I think is fairly egregious. Castingate blasting was hired by the provincial government to do blasting for a provincial highway. So the province was their customer. The province was their supervisor. The province set out in a contract what should happen if a piece of fly rock went AWOL, which was that they were supposed to report to the Ministry of Labor, and there was a Ministry of Transportation contract supervisor on the site at the time. And nobody, absolutely nobody in the regulated community thought at the time that if a piece of rock went sideways, that you'd have to report that to the Ministry of the Environment. The Ministry of the Environment had never gone to the construction community, to the blasting community, to say, we would like to be notified of these, please. They had never gone to their sister ministry, the Ministry of Transportation, which is the one to say, please, in your contracts, when you tell people what to do when there's a piece of fly rock that goes sideways, please ask them to call us. Because if they had done either of these things, they would have given the regulated community fair notice that they wanted to be notified, and then they would have been notified. So instead, they sit in the weeds. They don't tell anybody. This is their new interpretation of the Environmental Protection Act, which has now been in effect since 1971. This is brand new interpretation that the ministry made up, didn't tell anybody they'd made it up, and then they prosecute and convict castigate blasting with a minimum fine of $25,000. It's very hard to persuade the regulated community that they're being fairly treated when no one tells them when the government changes its mind about what an existing law means. Now, the Supreme Court has said, basically, tough luck. This decision that came out in, I think, December, dealing with Sovereign General Insurance Company. Now, in this case, the insurance company did something that I've done many, many times over the years for clients. If we have a gray area where the law is not clear or the regulator is taking a really unreasonable position in terms of the interpretation of an act, what can you do about it? Well, there's really three approaches, only three possible approaches. One approach is you can go to the Superior Court and ask for a declaration. That's very expensive and very slow. Most people can't afford it, and you can't get an answer fast enough. The second thing you can do is wait and see if they prosecute you. This is not something I ever recommend. Again, very expensive, very risky. So, well, what else can you do? So the sensible thing to do, it seems to me, is, and as I have always done, is write to them. Write to the regulator and say, all right, this is the gray area. This is our interpretation. If there's any problem with it, please write us back. And that is what a rational, reasonable person would do. That's what the Sovereign General did. They wrote to the Financial Markets Authority in Quebec, and they explained why they believe their broker didn't need to have a Quebec registration to sell their insurance products. And the regulator just didn't reply. They just didn't reply at all. They didn't even write back to say, we're not going to answer your letter, guide yourself accordingly. They just ignored them entirely. So then what happens? Well, so the regulator then responds without even a phone call with 56 counts, each of which has a minimum fine of $10,000. So, Supreme Court gets to make the law, I don't make the law, but that leaves us sitting for companies who are trying to understand the law with basically no options other than the Superior Court approach, which is, as I said, pretty impractical in most cases. Which means that that kind of issue is going to come back to sentencing, and that's where we get into the issue that minimum sentences have become extremely popular in environmental cases, very substantial minimum sentences. And I think that this is something where we are going to be having to look to the courts to go past the regulatory decision to lay 56 counts Several of the judges said that they would have collapsed the 56 into one count, which would have made a minimum penalty of only $10,000. And I note, by the way, that the Quebec company that actually sold the insurance policies was only received one count. It was the Quebec government chose to be extra punitive to the out-of-province organization. But they decided not to do it because it hadn't been fully argued below. That's certainly an area that I hope that the courts will think about in future. And one other example along the same line of a case that we dealt with last year was a Fisheries Act prosecution dealing with erosion during construction. Now, erosion during construction is a serious problem. Erosion into particularly sensitive streams can damage them very seriously for many years. If you go past a construction project and you see mud running off, that's bad. But in this particular case, the Ministry of Transportation had chosen to design the highway in a way that saved them money by pretending that there weren't going to be erosion problems, even though they had put the route for the highway through the most sensitive, most erodible, most unstable soils there are. There's a general scale of erodibility. It usually stops at 60. These were at 75. These are the most erodible imaginable soils. You look at them sideways, they're going to be erodible. And they were right next to a cold water stream. And so they put in the contract that the contractor was fully responsible if there was any erosion, that the contractor should prevent erosion by making sure that the whole highway project in any one spot was finished in 20 days, knowing perfectly well that that was physically impossible. So there was lots of erosion, and the contractor and the government were prosecuted, but the court didn't come to grips with how much responsibility should lie on the government, which chose to create the problem. They saved tens of millions of dollars by putting the highway there instead of somewhere where it was more expensive to build. Isn't that something that should get a little bit more attention? Okay, I see I'm running out of time, so I'm going to rush on for just a few minutes about regulatory orders. Regulatory orders are not really about sentencing, and I know you're primarily focusing on sentencing this morning, but I hope you'll forgive me with a couple of minutes on this. Because it's an example of something which is not only doing, I think, noticeable economic harm to Ontario, but probably will affect other jurisdictions as well. Strictly speaking, environmental orders are not punitive, right? You're not punishing somebody. But it feels the same way when you impose a very large financial cost on someone out of their own pocket. In this case of Baker versus Director, Ministry of Environment, is a case where the Ministry of the Environment, having failed to take any effective steps to regulate the use of chlorinated solvents since the 1960s, admittedly the Ministry of Environment didn't exist until 1971, was faced with a historic contamination by third parties. So we're in a situation where in 1985, a Canadian company bought a piece of land. We now know it was already contaminated. There is no evidence that the Canadian company that bought the land caused any of the contamination. This Canadian company had a parent company whose head office was in the US. Our client was a director of the parent company. He was only a director of the parent company after the Canadian company had shut down its operations at this site. He did absolutely nothing wrong. While he was an officer, sorry, not an officer, he was a director of the parent company didn't do anything wrong. While he was a director of the parent company, the subsidiary company didn't do anything wrong. All that the subsidiary company did while he was a director of the parent was spend $20 million that it didn't have cleaning up contamination that was left from a previous owner of that property, and some contamination that was from another site altogether. They went broke, partly because they spent all this money on the cleanup, and the Ministry of the Environment responded by putting issuing an order to the individual officers and directors to pay for the cleanup. Now, what really makes this unfair to me, aside from the fact that the order was imposed without fault of any kind, and in my view, the order was illegal at every stage. Ministry claimed to be relying on a spill, which, once we checked the facts, they knew was of a completely different contaminant and had been cleaned up at the time. So the factual basis that they pretended to be relying on, they knew wasn't true. But there is no remedy, because under the Environmental Protection Act, as it's been interpreted by our regulator and our Environmental Review Tribunal, there's no stay pending appeal. And the ministry designed the order so that the directors and officers had to immediately spend $1.5 million a year. In the 5 years it would have taken to get to the Supreme Court, that's more than $5 million. Well, it's probably more than $6 or $7 million. And there's no way to get any of that money back. There's no provision for compensation if you've been forced to spend vast sums by an illegal order. There's no compensation mechanism provided for. So they settled, sending a chill through the directors and officers throughout Canada, and I hear it's starting to spread about American directors who have sit on boards that have subs in Canada, and of course it's frightening people because it's such an unfair situation. The ministry's interpretation, which I thought was ridiculous, was that you permit contamination if you don't make sure that the corporation doesn't go bust before finishing the cleanup, which I think is nonsense. And what again I think is a misinterpretation of this section, which is sort of neither here nor there. But it means that under this regime, there's liability for anybody who ever sat, now or in the past, on the board of any organization that owned or occupied land where there's contamination on or off site, whether it was caused by that company or not, whether or not the cleanup's triggered by a change of standards, whether or not some of the contamination comes from somewhere else, and whether or not there was an insolvency. So what we've ended up with is a situation where we do absolutely need vigorous enforcement of environmental law. I think we need to do far more than we do, although it's also true that a great deal of the worst pollution is legally done, not illegal, and that's a problem for Parliament and not for the judges. I do hope that anyone who's in a position to do environmental sentencing, first of all, looks at fairness and looks at the role of government, looks at whether or not it was reasonable for the person to have prevented this particular incident, given all the various other things that they have to do. I do also hope that you look at the validity of the science that the government relies on. It's one of our long-standing difficulties is that a lot of judges, with all due respect, didn't like science in high school and will tend to accept government data whether it's valid or not. So that's basically the bottom line. I hope you'll think hard about fairness. I hope you will insist on good quality science and not just whatever the government throws your way. But I hope that when there is, that you will take environmental impacts very seriously and help us reduce the rate of destruction that we're causing. So I hope that's helpful to you. If anybody is interested, we do an environmental blog. We'd be glad to add anybody's name to it if you wish. Just send us an email and we'll be glad to put you on the list. And I hope somebody has questions. Thank you very much.
Very much, Dr. We do have some questions, and by the way, I would say that the presentation came through along with the PowerPoint perfectly, so there were no problems in that score.
Thank you.
The way we are arranging questions is you have cards, and you can send them up, and as I said at the beginning, people on the web can send their questions through to the email address on the home page. I've already got one question, which is a fairly specific one that's come in. for offenses which comprise a failure to exercise due diligence to prevent an offense, that failure is an element of the offense and should be proved by the Crown. So would that, in those circumstances, reduce the burden on directors and officers?
I mean, it does to some extent. The question, the challenge is the test that the courts apply. So I think about, and I'm not going to come up with the name of the case immediately. I think it was Falconbridge some years ago, where there was an industrial accident caused by the overswing of a gate. And the company proved that no one foresaw the overswing of the gate. No one saw, I mean, people knew that the gate did swing too far, but it never occurred to anyone that it was a safety hazard. Never, ever, ever until the terrible day when a passing train caught the end of the gate swung shut, the far end of the gate clipped the back end of a parked car that didn't have its brake all the way on. The car rolled forward and killed somebody. So the court said, well, you know, that's it's not good enough because people knew the gate swung more than it was designed to swing, and even though they didn't know what the consequences should be, they're still liable. I mean, I think that the challenge is for the court to have a realistic understanding of how difficult foresight is of these accidents. And when you need to prevent everything from going wrong, how many things there are and how hard it is to do. So you're right, the Crown has the onus of proof, but what will the court accept as proof? Well, in the Falconbridge case, the court said, well, everybody knew that you could see by looking at the gate that it swung more than 90 degrees, right? Well, that's right. And it doesn't matter if no one foresaw, not the government, not the Health and Safety Committee, not the government inspectors, absolutely nobody ever foresaw that that could be a problem. Too bad. And it's that kind of decision making that makes me think that the people making the decision have never had to run this kind of a business, have never had to make these kinds of choices. How else would they say it doesn't matter that no one foresaw this? Why doesn't that matter? Well, that's how it seems to me. It seems to me that if you have a council of perfection, that people should foresee everything and prevent everything. It's nice in theory, but it's not practical. And if you put burdens on people that they cannot reasonably discharge, I don't think you get better behavior. I think you get worse behavior. I think you get better behavior from people if good behavior, reasonable efforts, conscientious effort is rewarded, and bad behavior is punished. If you punish the conscientious just the same way you punish the bad people, I think you reduce the incentive for good.
Another question. This goes to a case you mentioned in your remarks, the La Souveraine case, involving mistaken understanding of a complex regulatory system. And it's really a two-part case because it seems that the Supreme Court arguably left a little wiggle room there in terms of egregious cases. But the two-part question, I guess, is how do you strike a balance between the sort of situation where the government did just nothing and then prosecuted? So how do you strike that balance with having the law enforced? And secondly, who should be striking that balance? Is this something the legislature should be doing, or is it something the courts themselves should evolve over time?
I don't see any indication that the legislature will deal with it. I don't see any appetite whatsoever in the regulators, who are the ones who propose the legislation, to have their ability to act badly limited, because they're the ones doing it. So I don't think we're going to see anything coming from the legislature. In terms of the courts, I agree with you. The Supreme Court said, well, if it's egregious, maybe we'll do something. But I thought this was egregious. They wrote in, they explained their position, they had a reasonable interpretation of a somewhat unclear statute, and the regulator responded by laying 56 charges, but only against the out-of-province people. I mean, what does the court need to see to make it egregious? It was a $560,000 minimum fine. Okay, it's an insurance company, maybe that's a rounding error for them, but it strikes me that that is bad behavior. So when all else fails, I do go back to basic moral principles. Is it fair not to tell somebody the rules and then punish them? I know the Supreme Court said we need to have, uh, uh, we need to make it not too difficult to enforce. But I don't think it would be harmful to put more onus on the regulators to make changes of the law clear and to make interpretations of the law clear when they just change their interpretation. And that was the issue in Baker, and that was the issue in Castonguay. It's not that someone should have been tipped off because the law was changed. The law wasn't changed. The only thing that changed was that the government changed its opinion as to how it was going to use it. So yes, I do think the courts which specialize in fairness should be thinking hard about fairness, including the fairness of government conduct, more than they do now when it comes to regulatory offenses. Sorry. And I think the case-to-case basis is a chance to look at, well, in this circumstance, Castonguay, for example, why shouldn't the government, when they're hiring someone and specifically setting out a procedure what to do when there's fly rock, why shouldn't they be held to that? And again, it's not as if the government had anything to offer. The reason you report spills to the Ministry of the Environment, the reason that section is there, is so that the ministry can take evasive action. So the classic examples in the Muskoka Baptist Conference case where their septic system overflowed and they poured raw human sewage into the lake close to somebody else's drinking water intake. Well, you needed to have the ministry notified so that everybody else on the lake could immediately be told to start boiling their water, chlorinating the water so that people didn't get sick from the diseases that come from human sewage. That is an example of where the Spills Action Center immediate notification is important and valuable. But in a case of a piece of fly rock, the ministry knows nothing about blasting. They had nothing to offer to the response. They would not do anything different than what the Ministry of Labor did, and they were already there. So yes, I'm hoping the judges will do it.
One last question, and it is something you haven't touched on, but in terms of moving in the direction of distinguishing people between defendants such as, on the one hand, Mr. Sinclair, the snidely whiplash, if you will, the obnoxious, despicable, and totally incorrigible defendant, and the Dudley Do-Right Mr. Baker, who seems like a pretty honest citizen. Do you think that at least at the federal level, the criteria now being introduced in the Environmental Enforcement Act, which we're actually going to hear about in the next session, do you think that moves in some direction towards resolving that sort of problem?
I think that creative sentencing is a very important tool for the court in giving much more flexibility to how to respond to the differences in the individuals, and also in getting an opportunity to do some good as a result of an environmental offense, as opposed to just having somebody go to jail or money into the Consolidated Revenue Fund. I haven't yet seen at the federal level a lot of interest in this question. Is it fair to enforce a law without telling people what you mean by it? A classic example being the export of waste electronics. There were a number of years in which there was a very open trade in waste electronics between Canada and China. And the federal government did nothing to go out to that market and say to them, listen, as we understand the Basel Convention, this is illegal. We are giving you fair warning, shut it down. Instead, they just started by prosecuting people, just as in the Souverain General case. So I haven't yet seen an approach at the federal level, and I should say also the Gemtech case was an even worse example. I would like very much to see the federal government taking an approach that to make more effort to make clear what they mean by things, to give people a fair opportunity to comply before using enforcement to punish them. But if they're going to change, I'd be delighted. Does that answer the question?
Yes, this is all. I appreciate very much your being able to take the time to join us today. So thank you very much.
All best wishes to the rest of the conference, and thank you. I'm sorry again about the confusion about the start time.
I will take a 5-minute break now. I think people have time to run out, get a coffee, and do whatever. We'll be back in 5 minutes to talk about some statutory developments. A lot of what we've heard so far has been how courts have dealt with things. Now we're going to hear about how the legislature's responded.